Welcome back to Ask the Patent Attorney. Nate Lewinsky here with Vin LoTempio, Klaus Stangler and LoTempio out of Western New York and from patenthome.com. And we got another question here, and the topic today, or right now, is about non-disclosure agreements, NDAs. What are the benefits? What are the pitfalls? Is it something that I do myself? Do the company, the company I'm interested in, I have an idea, I'm trying to get it sold, I'm afraid to talk about it.
Well, that's the thing. Most inventors are, and they're very paranoid, and they should be, because people are despicable out there, and they're going to steal your idea. And there's the bottom line of protecting as a patent attorney is to get a patent, to have a patented idea and go into the discussion with that investor or that manufacturer with the patent and say, here, you can't steal my idea. The problem is a lot of people don't have patents, and it takes a while to get them, and so we've come up with this device in our office, prepares these for them. We can prepare them for you. We prepare them for inventors as non-disclosure agreements. They call them NDAs as the vernacular. And it's a contract. It's a contract between the inventor and the person that they're going to tell their idea about, whoever it is, whether it's a marketer or a manufacturer or somebody, an investor that's going to invest into it. So the whole idea there is if they do steal your idea, there's a written contract between you and that investor, and you have something to sue them on. Whereas if you didn't have that written contract and you didn't have a patent, they can just take your idea and run with it. Mm-hmm. Mm-hmm. So one of the things you want to think about as to when you go to sell this idea is to do some research. Research who you're going to show this to. It's simple now on the internet. You can go and search almost anybody and find out about them. And you want to work with reputable people. Investors or investment people are not likely to go around stealing ideas because nobody's going to go to them in the future. So if you have a reputable person, I wouldn't be so paranoid about going to them with an NDA or even finding out if they have their own NDAs. And a lot of these companies will have their own NDAs. Now, there's a problem with that, too, because some of them are so one-sided that even if you sign it, you're really not getting any protection at all. But to tell you the truth, if they're really going to steal your idea, that written contract, what's going to stop them? Hopefully, you're dealing with somebody that's reputable and that they'll like your idea and they'll find it worthwhile, and then they'll purchase your idea, and maybe you can work up a licensing agreement that our office could help you with, preparing and working out the details, and you could work up a licensing agreement. So,
right.
So what are some of the type of things that you do once you've come up with this reputable person that you feel that they're in a position to help you, or either to manufacture or market or distribute your product? Well, when you get in through the gatekeeper, the gatekeeper mm-hmm. at the secretary at the office, you want to talk to somebody that has the ability to say yes to your idea. You don't want somebody with vice president in their title.
Right.
You don't want somebody in the research and development department, because his job is to come up with new ideas. And what's he going to do? Take your idea to his boss and say, hey, this guy from outside came to us with this idea, and I think
right.
you should use it. Most likely, he's got the ability to say no, but he doesn't have the ability to say yes. We like this idea, and we're going to go for it. So find the person in the company, in whatever way it takes for you to get in there and do it. You got to get in there. It takes a little internal fortitude to do it. Find that person who has the ability to say yes and get in front of him. Again, it's if your idea is to melt ice off an airplane, and you want to get in front of the president who's doing that, and you got a better idea, you probably have a better chance of getting to see him, or if you have the new Tickle Me Elmo and going into Mattel, because there's 1 million people with a Tickle Me Elmo doll, and there's not a lot of people with the idea to melt ice off an airplane wing. So that's important as to who you get in there with, and it's hard to get in there with.
Well, and another thing I was going to say now, to have this non-disclosure agreement and to work up a licensing agreement, to take those steps, which seem to me like it's not exactly as easy as knocking on a big company's door or something like that.
None of this stuff is easy.
None of this stuff is easy. But why would I do this as opposed to getting a patent and controlling the idea in a much more concrete manner? I mean, patent is the best way to go. This is an alternative. Why am I choosing this alternative?
Well, we'll talk about this in another episode too. But here we're talking about, you want to just see if there's interest in your idea, and you're just trying to send feelers out there, and maybe when you present your idea to these investors, you could allude to what your idea and what it can do, and maybe see if you got some sort of a feeling that if you had this idea that they would jump at it, and then you can put the big money into a patent, because it's not an inexpensive endeavor to have a patent, and maybe you'll even just file a provisional patent just to get things moving and to talk to them and have something in writing that locks you up. But essentially this NDA, it's a way to get around in market without getting a patent on every one of your ideas. And that's another point I was thinking about. When you call and you get your foot in the door, you get past this gatekeeper, you don't say, I'm an inventor with a new idea and this is my first and only idea. Present yourself as a product developer that's got all these great ideas, and I'm sure you're going to be interested in this one. You make that presentation when you get there as a professional presentation, and you should have that worked up and ready to go as a professional presentation. When you get your 60-second elevator interview or get yourself in front of it, you're ready to go.
Yeah, because I was going to say, it's got to be hard. You got to be towing that line. If you're not going to be giving them specifics, I know if I was president of a big company and you were saying, I got this great idea, but I kind of don't really want to tell you what it is. It's like, well, you can kind of shine my shoes or I'm out of here. You know what I mean? So it's got to be, I'm sure there's some difficulty there, but none of this stuff is easy. And, it's a whole battle. And that's why calling a patent attorney, they're going to give you that help.
Yeah, we could help you with NDA. We can help you prepare it. And certainly if it's coming from a patent attorney, they know that you're working with a patent attorney, and that perhaps that if they do steal your idea, you'll be coming after them with a patent attorney. It gives you a little bit more power. But if you have any questions on this regard, if you need an NDA, call my 1-800 number. It rings right to my cell phone. Ask some questions, and we'll answer it on the next show.
Sure. Yeah, and we got some more stuff to go about this and some other segments down the line. But bring us your questions. Keep watching, and we appreciate your time.
Thank you.
Thank you.